Well, we are live in 5, 4, 3, 2, 1. Are you guys here?
Yes, Mr. Paula, we are here.
Okay, thank you. Well, the plan, yes. Good, 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 good. Good to hear from you. Well, the plan was always to introduce ourselves to these modules. We've done a lot of work on module 1, so let's go to the second one and see what's actually in there. The objective is to try and move you from, if you have this module printed, you have moving you from page 1 of this to page 7 of this at least. Page 7 of this, you would have completed everything you need to know about the first area of that module, which is generally almost the same things you studied at the previous module. But what you will see is that it now deals with the application of those things. All right, so let's see what's in there. If we then go to this module, you'll see that this deals with the professional conduct. So professional conduct in a sense that, yes, I agree how you should conduct yourself as a professional, how you should behave maybe, but also professional conduct as in the actions which will be your professional actions as a legal practitioner. What are the things that you'll be expected to do? And you say, wow, but Mr. Pala, if you're looking at the Legal Practice Council, that has got much to do with my principal and my boss and everybody else. Me, I just make coffee. Well, you work in a law firm, and when the world looks at all of you, whether you bring a cup of coffee or something, they see legal practitioners. And the expectations is that you will deliver legal service from a hello, how are you, to a yes, we have won the case. But all those steps in between will include you. If you work at the reception, they will include you receiving somebody at the reception. And when you receive them, how you receive them, what you say to them, who you refer them to. Sometimes these people are not just coming in, they're just calling. Somebody calls and he says, I have a matter here, I've been referred by so and so. What do you do first? Do you dive into the issue or you get their contact details? If you get their contact details, fine, but don't you want to know preliminary around what is really happening? Just a background of the story so that you should know what's going on. If somebody says, hi, hello, is Mr. Pala there? I've been arrested. What do you then say? I mean, there's always you going, you've been arrested. I've been suspecting you. Oh, it's okay. What are they charging you with? Or what are they saying you have done? You, it's a very simple question, but it's not the same as what have you done? The answer to what have you done is nothing. Nobody admits to having done anything. But what are they saying you have done? Then they will say, well, when the police arrested me, said I exceeded the speed limit. I was driving 161. Remember our example last time, or 160 actually. And then they arrested me. So, oh, sorry to hear, man. At what police station are you at? Those kind of things. Are these things just idle talk? No, you're trying to establish how far is this place, what schedule offense this is, what needs to be done, where can you get bail? Must this person now appear before the court? For example, if he was drunk, it was a different issue. He's driving 160 and he's drunk. Now it's one issue on top of another. But just only driving 160, there could be some explanation that we can work out something here. And perhaps we end up with police bail, and then you'll come and explain later. Those kind of things are the things that we then gather as paralegals when somebody calls the office. Now, ultimately, you pick the phone and say, Hey, Mr. Jacobs, your client has been arrested, And Mr. Jacobs will first then ask, for what? And that's when now you download and you say, for this. And this also might be an issue. He is at this location and this and that. All that information you give, it's important to assist the attorney, Mr. Jacobs, to now stand up and go and do something about the situation that his client is now being arrested. But the preliminary information comes from a paralegal. So if we move right along, those of you who are working in civil cases, let's then discuss something around maintenance. If somebody says, I have a maintenance issue, please help me. Please write for us in the chat box. What kind of information would you ask from this person? And those who have never handled those things, perhaps think of a situation where a friend will say, I've got a maintenance issue and you want to refer it to me. So I'm going to send this to Mr. Pan. But at least what should you tell me about this case? You can write in the chat box so long and we'll be able to read and see what you guys are thinking. And like I said, we want to know whether this divorce has been finalized yet. Is there a settlement agreement? Very important, because it will help us to see what are the terms then of this whole maintenance thing. When it assess the maintenance of a child, their income, their expenses, it's very important for you to now go and determine whether they can afford maintenance, right? Hendrina says, who, what, when? Well, they'll say them, that, whenever, because. So, so you need to ask them specific issues. So who's the father? What are they looking for? Who's the mother? What are they looking for? Do they want money or the clothes? When do they want this? When have they issued the summons? Have they issued the summons afterward? What are they even doing? So you have to be more specific, right? And I like what Hendrina is saying. It gives you the cues of the structure when you ask somebody who's coming for a consultation, who is the person? And the trainer says, yes. So you need to get those questions in that structure. It's first put there. So who, what, when, and why, but admit to that structure and make sure that that structure gives you more details and it helps you to give to the attorney who's dealing with the matter, or even yourself if you are at a paralegal practice where you could assist families like Necro. Is Necro still there? And all those associations. Yeah, what is the maintenance for? Yes, it could be about clothes, instead of sometimes about school fees. When last did they make that payment? That's also very important. Is the father liable for maintenance for the children? That's also very important. Sometimes the person could be liable for maintenance, but sometimes they also have a trust fund, and the money goes through a trust fund and other issues. And sometimes they're unemployed and the mother is gainfully employed. Remember, maintenance, both parents must maintain the child in line with the affordability. So you see, now you are asking professional questions and you are getting a civil case resolved by asking questions. Interestingly, when lawyers are paid to speak, we actually don't speak unless if my boss says, unless if you guys are paid. Yeah, well, unless if we are paid. But the thing I wanted to say is, unless if we are making some form of submission or another. Have you noticed that in most instances we ask questions? We either come to court to ask leading questions if we are leading a witness, or we ask probing questions if we are cross-examining. Just only later do we make submissions after we have submitted the heads of argument. When we draft affidavits, we ask questions. What happened? Where? When? And you ask these things to help to draft into the affidavits. So, case in point, always make sure that when you're dealing with these matters, you're able to ask the right questions. But if you're going to ask the right questions, you need to understand the areas of law you're dealing with. In the previous discussions and the previous modules, we have seen that there's public law, and we've gone to length and explain it. We've said there's private law, but there's general support of public and private law from other pieces of legislation and legal frameworks that we will now discuss. So private law, we've done much discussion about it. In the previous discussion, I'm going to pass through. Indigenous law, in your class, we even read through the Constitution to see where it fits in. International law, we have discussed it, but here's the one thing now new about it. It doesn't just say international law anymore. In this book, they now refer to private. Can you see? Private international law. Why? Because what they are now discussing is international law that does not only have to do with the state, it is international law that has got to do with people in different states. For example, they are giving you an example there in the book, but I'll give you my example. My example will be, what happens if a person is has died in another country, but they've got assets in South Africa. So in that country, say Australia, they give them the letter of executorship so that the master of the High Court in Brisbane says you can execute the estate of the deceased and take his properties and give to his children and all of those. But this is Australia, and some of those assets are actually in South Africa. Can we now say that letter of authority from Australia would be used in South Africa? In the chat group, write and tell me what you think. Will that work? While we are asking whether it will work, yes or no, somebody could also tell us why they think it will work, and somebody can tell us why they think it won't work. You must have some reason. Then it says, no, it won't work. Somebody else, or you can now tell us why you think it won't work. It's different jurisdictions. You see, Shimona says it's in different jurisdictions. It means different countries, different laws. It's never gonna work. You need to take that letter of authority and localize it. Yes. Even though it's issued by a court or ecclesia by the master of the high court, that master must come to this jurisdiction. Interestingly, the master in Johannesburg is not the master in Pretoria, even though once the letter of authority is issued, you can use it to affect properties all over South Africa. But the jurisdiction also, we'll later discuss this, affects where you can lodge the deceased estate application. We'll discuss that at later stage. I think the some chapter is on study guide 7, I think, somewhere down the line. Now that we've looked at this, we go back and say, so you see why private international law is there? It now helps us to say, how do we apply for the letter of authority from Australia to be used in South Africa? And how do we follow? What processes do we follow? Where do we go? Which forms do we fill? Which court do we go to? Which office do we go to? And we follow all those processes. Well, we've talked about general support of public and private law. The general support at times does not seem to be law, but that support influences law. We have discussed something in the morning, like they say to you, you need to submit an assignment. So if you're going to submit an assignment, what do they really mean? Well, dictionary meaning of things, submit the assignment means take the assignment, go to the assignment box and submit it there. So you generally take it and drop it there. On the other hand, we expect the assignment to be a physical document. You typed it, you printed it, you signed it, you put it in an envelope, write your details, submit your assignment. UNISA old school used to work like that. You used to have assignment boxes, and you literally would have to take your assignment to UNISA. What the fun! But we used to have fun doing it, driving all the way to Sunnyside, and you drop your assignment there. You looked very sophisticated in a brown UNISA envelope. Those were the good old days. But then again, what then since happened, you see that institutions like UNISA and yours now, you are studying like distance learning, but you're studying online. You'd find that you can now go to eLeader. And when we say submit an assignment in eLeader, we actually mean do the assignment online, attach it to some sort of portal that will let you send the assignment over to me, PDF, and I mark it online. Or go online and find some form of quiz. You'll start seeing this in the next month or so. You'll see some form of quiz online, and then you go to the quiz and click yes, click no, or true, false, or even type in some information. But once you are done, for you to submit that assignment, you need to click on a button that says submit or okay or send. As we say in Pretoria, yesterday, drag the groen knoppie. So once you drag the groen knoppie, the assignment will come here by me. But until then, you can type the assignment for all you care, but if you don't press the button, the assignment will not arrive. So what I've talked to you about now, I've talked to you about the definition of what is meant to submit. It's to send and to bring something to a place. But context is important. If you're going to submit an assignment which is paper, the assignment which is paper, you're going to have to submit that assignment by carrying it and taking it to a place and submitting it there physically. So if you're going to submit online, you said you'll press the button. What are we discussing? Are we really discussing assignments and submit? No, we are actually discussing the interpretation of a rule that a student must submit an assignment by the 30th of March. That interpretation is subject to direct interpretation of the word submit, but it's also subject to the context, how you'll submit the assignment. What are the other external factors affecting the assignment? So that it's a whole course in its own at university. It's called interpretation of statutes. And if you studied LLB or you are studying LLB, you should have seen the course. The textbook is greenish on the outside with a school bus or something like that displayed on it. So it haunted me. I still remember the textbook. You would also meet it if you've not done it yet. You'll probably find this at third year, second year, third year. It's interpretation of statutes. But why is this important? This is important because if you interpret something wrongly, even if you interpret it right and you don't get the context right, you get it wrong. It has to be properly interpreted within the context. Forensic medicine, those of you dealing with road accident funds, you need to submit medical reports and complete the road accident fund form. If you're working with the road accident fund, please on the chat group, write what is the form called? It's a rough who. It's got a number, I think, on it. So that road accident fund form, somebody will type now, will indicate what kind of injuries and all of those. It gives a proper, you need to submit your rough form 1 and all of those. So those road accident fund forms, they assist us to assess if there's a matter and whether this matter is not prescribed, but what injuries are there, what kind of claim are you claiming, and all those things. So once the forms are completed, then we are able to process the road accident fund claim. But one of the biggest issues that go with that claim is proof that the person has been injured. Proof of injury, medical records. A person issuing medical records must be a medical professional. Well, comparative law, we've done it the other time when we were discussing prescription. And then we said, for example, if it's a road accident fund, hit and run, you guys said 2 years, please, from the day of the accident, not from the day the client comes into your office. And then we said 3 years if we can identify the driver. Philosophy of law or jurisprudence, we've discussed this, for example, when we're discussing Ubuntu and we're discussing law is politics, where the leading party will always pass a particular rule or act or law based on their constituency. Legal history. The previous module has assisted you with the legal history so that you understand the jurisprudence and how it works. I'm thinking legal history so that I can give you something nice you can remember and you laugh about sometimes so that it makes sense to you. Okay, so once upon a time, I had to write the heads of arguments. And in this head of arguments, I could not find a way to explain this. So somebody was arguing that a certain tribunal does not have jurisdiction over the case, and therefore the case should have been referred to court. And yeah, sure, I would have written it. Think I would have gone to the act and say this is the proof of the jurisdiction of that. So to get my mind rolling, I actually got out a Brenda Fassie song. It's straight lender. So everybody in my office laughed. They said, really, are you going to do this? So I literally quoted the song and put a footnote. And as Brenda Fassie said, it's straight lender. There's no really need to argue the jurisdiction of an institution if the act itself says here's the jurisdiction, if the practice directive itself says here's the jurisdiction, I fully rule, I straight lender. And yeah, you can guess, I actually won. But it was fun to Brenda Fassie in legal papers. So there are those times where the history of things are linked to how we lived and how we did things. If you remember, Brenda Fassie is an old situation. The discussion in that, when I quoted this Brenda Fassie situation, we were talking about SPUMLA, the Act for Spatial Planning. And for you to understand spatial planning, you need to understand it in the context of you need to understand it in the apartheid era laws that had to do with Group Areas Act. That's actually that was what the law is called. And how people were moved from Sophia town into different areas of Soweto, Alexander. But when I wrote this, it was about people who have a right to own townhouses and then rent them out and do as they wish about them as long as within the law, because it affords them the right to use their properties. And the background of how Group Areas Act has segregated our people, and today you look at there's a community that is generally Zulu, Africans, Sotho. We are so segregated in terms of race and all those things. We could have simply been one homogeneous society. Like if you look in the suburbs, there's just different races in one, or in the security estates, there's just different races in one security estate. But if you go to lower living standard measures, when we started the course, we explained the living standard measures. You find the lower the living standard measure, the more segregated the people. And this, if you don't understand the history of South Africa and the history of spatial planning in South Africa, you would take that law on spatial planning out of context. And I had to explain that context. And that's where it ended up with is straight lender, funny rule. Now, the main areas of the South African law can thus be compared as follows. And we have put a table for you. You can do the comparison and you look at it and see what it does. It's a simple enough comparison, so you can look at it. I'm going to move you a bit to this discussion. This discussion where you look at substantive law and formal law. We have had this discussion when we started our discussion in the beginning. We discussed criminal cases and say, in a criminal case, there will always be the prosecutor on the one side. On a civil case, there will always be two lawyers arguing the same thing. But hey, hang on, there's something different though. If this was going to be a road accident fund argument in court, or this was going to be a divorce argument or a maintenance argument, as we have now said, there will be a need for us to follow procedure first. You cannot go and sue the road accident fund without first issuing RAF1, you guys said. So you need to fill these forms first. Get this form submitted. Get your own copy or your letter stamped to say you've submitted on this date. Count the number of days. If they fail to respond, send them a follow-up letter. If they fail to respond, issue summons. They receive the summons, you wait. In this number of days, you send them the notice of bar. They don't respond in 5 days. You go to court. You set the matter down. And all of this, you see, you're not arguing whether the person was injured or not. Eh? All that you and I are talking about right now is the forms and the procedures and the things and the steps you must do. These steps, the forms and the procedures and the things you must do, is generally known as formal law or procedural law. If you're looking at criminal law, you'll be looking at the Criminal Procedure Act, for example. If you're looking at civil cases, like we talked now, the divorce, maintenance, the same, you need to send the summons and say, well, enough is enough. I am divorcing you. You need to respond to the court within a certain number of days. And that gentleman or that lady will have to respond. Once they respond, they need to file their own plea. And we probably would have to sit and have a settlement agreement. You've seen it somewhere in the chat. And we'd have to deal with the children and all of those. Those are the documents that fly around and they get things done. But once everything is done, there is a copy from the children's advocate, for example. The endorsement is made. It is now that we now go to court and say to the clerk lady, is it the 4th floor there in Pretoria? The case is done, CC. Can you assist me with the date? She says, yo, the dates are 3 months down the line. And then she'll assist you to find the date. And she'll come next week. You come next week, then they give you a date. And then you arrange to go get the file paginated. All those processes have got nothing to do with where were the people married. Were they married in community or property or not? How many children do they have? Who will live with a child where? What will be their maintenance? No, that's not the issue. What you and I are worried about is issuing a summons. We get the other party filing the notice to defend. We get a plea done. We send an email and letter to the other party, say, dear colleague, can you see now that there are children involved and there could be issues of maintenance, and can we narrow issues down and have this discussion, a roundtable discussion to try and draft a settlement? They come first meeting, they don't agree, they walk home, everybody's very angry, they don't even drink the tea. Then we set up a second meeting again, and ultimately we have a settlement agreement. We take the settlement agreement signed by both parties to the children's advocate. The children's advocate looks at the settlement agreement. The children's advocate says, how not endorsed. They send it back to us. We meet again. We get it fixed. We sign it. We send it back. The children advocate says, Yeah, Moisio, I like this one. And he signs on it. He gives us back. We go to court. We file it. We ask CC for the date. And CC says, "What next week?" Then you come next week, you get the date, and you go paginate the court file. You go make sure that the original settlement agreement and your marriage certificate, you request the magistrate if you cannot take them with, so that you bring them on the date of the court. The magistrate agrees. If they don't agree, they keep it. This has got nothing to do with who's divorcing, who's not divorcing, who are the children, how old they are. And I know I'm rehashing this, but the point is, I'm trying to show you that right now, for these people to be divorced, we are following procedure. And these are the formal steps. And these formal steps that you are following now, you can find them in the rules of the courts. The magistrate court rules, of course, if it's divorce, the regional courts would follow those rules, or the high court if it's a divorce for people who are married customary. They usually will have to do the high court route. But you follow those rules and make sure that procedure is followed. Same if it's going to be a criminal case, the same. Somebody's arrested, what do? You call in, visit them, find out who's the investigating officer at least, find out what they're arrested for. Now you know the schedule. Find out if you cannot arrange for bail right here and there. Say, no, bruh, the schedule, we must go to court tomorrow. Tomorrow morning they go to court. But because now you know better, you say, well, my brother, have you checked the address of my client? Because I don't want to arrive at court tomorrow and we have a dispute around the address of the client. The matter gets postponed over the address of the client. And further, are you going to oppose the bail? Because the investigating officer can. If he says, yeah, I'm going to oppose this, but why, bruh? And he explains why, and he's got his reasons. You come to court, you can be able to counter those reasons. So you're not ambushed. So you're able to agree on procedure. If you're going to oppose, probably you'll file an affidavit if it's a serious offense. If you're going to sort out the proof of address, you'll bring the proof of address. If I were you, I would go the whole 9 yards and get an affidavit from his wife or his mother and make sure that the mother is also coming to attend to say, yes, it's my son, he lives with me. And it will solve out that whole situation of we don't know where he stays. Check your client if they've got a passport. Make sure that if they've got a passport, surrender the passport, go get the passport from their house, speak to the investigating officer and say, hey, my client has got a passport. Here's the passport. I'll bring it to you today. Or can I drop it by you tomorrow morning just before court, my brother? Or do I give it to the prosecutor or whatever? You make sure that the travel documents are given to the court and you don't have a situation where they will say your client is a flight risk. You close those loopholes because you've been to bail applications and you know what is required. You say to your client, do not SMS somebody who complained. Don't accept if it's a domestic violence thing, don't send a WhatsApp to your wife and say, you see, when I get out of here, I'll show you. If you do that, you've intimidated a witness and therefore you cannot be released. So what are you doing? You are doing procedure. These things I'm telling you about the bail, they're in Criminal Procedure Act. So you deal with the procedure and not much about the substance. Okay. Once that is done and I've now said the word substance, let's skip and go to the left and talk about the substance. The substance now, it's all about the facts of the matter. It's a domestic violence thing, yes. What really happened? Was the wife beaten by the husband? Injuries? Was it aggravated or was it just a push? Was it the first time these guys are arguing? Were they witnesses? are the children. Did the children witness this? What is the performance of the children at school? I will go that far so that you can now find out whether this is affecting the children, because it might be brought up by the prosecution and say, yes, you cannot let this guy off the hook. I mean, he now makes the children fail by always harassing and intimidating his wife. All those things, and you put them together. So domestic violence case. So you check all those details. You check set details, but what is the word you're looking for? You check all those facts. So substantive law deals with the facts, no guesswork. I remember saying to a client in the morning, and this phoning is hysterical. I said, but look, here's the thing. We can go to court and tell them how you feel. This is unfair. It's not good. How can they say something like that about me? This is bad. I don't like it. No, no, no. You are telling the court your emotions, but you can come to court and give facts. Show me documents. Show me dates. You remember the when, where, which was typed in the chat group? Show me that. Show me timelines. Then I would know how to defend your situation. Show me WhatsApp messages. Show me give me recordings if sometimes these arguments were being recorded, so that I'll be able to defend this situation better, because I now have the facts. That gives you substantive law. Substantive law, they say, provides a means for protection of rights and duties. So you've got the means to defend your clients with, because it defines those rights and it tells those rights. But more than that, it gives duties which your client must be able to adhere to. Remember this rule: everybody has got a right, but to every right, there's an equal responsibility. You've got a right to listen to beautiful music, but you've got a responsibility to play music in such a way that it doesn't affect your neighbor. So it's rights and responsibilities. Interestingly, at point 3, they show you where these things come from. Roman Dutch law focused on substantive law to define and protect the rights of and duties. You say, wow, interesting. You remember the gentleman Justinian we discussed in the other book? Justinian, you said, wrote the rules.
I was just sending my groceries to my mom's place. Oh. Yeah. Oh, you can do that. You can send packages. Yeah, like Uber and whatnot. Yeah. Is it reliable? Yeah, it is reliable. With the Uber, that's one that I use. It's either with a scooter or like that could be.
Precious, I don't know what to answer though.
Next, I can let it easier. Is he still trying to reach you?
Precious? I don't know what to say to the gentleman. Okay. So maybe I shouldn't answer the gentleman. All right. We back. We couldn't have Precious, so let's continue. Roman Dutch law focused on substantive law to define and protect the rights. And we looked at Justinian, right? And we saw Justinian had the law put together in some books. In the chat group there, if you can still remember, what were those documents or books called? Write the one you remember. Yes, the codex. The other one had something to do with the university. What are these university called? You can quickly browse the other book. You'll see them. But these things that Justinian was writing was how the Romans deal with their citizens. and everything and the procedures and the rules of how the Romans dealt with their citizens was written down. For example, in the Codex, as you have put it. Now, if we are going to say you need to file a plea within a certain number of days, if you don't file the plea, we will continue and get a default judgment. Alternatively, now that you filed the digester, yes, thank you. Now that you have filed the plea within a certain number of days, we will do the following steps and do the following steps and be able to set the matter down in court, of course, issue you the notice of set down and everything. But once we are there, all these rules must be written somewhere, and we've already said, go find the rules of courts, find the rules of the magistrate court, and for the purpose of you figuring out what I am talking about, go find a rule around notice of bar. When can we issue a notice of bar? So go to the rules of court and find the notice of bar. Interestingly, it will show you other steps that are related to it. If you've got my favorite research thingy, go there and search a discussion around notice of bar. If you're using Judah Stats or you're using our other friends, search there, they'll give you a commentary around it. But it's not notice of bar. They'll also tell you what rule you find it on. Well, once we are done with the law must be codified and the law must be written down, you look at the other side. Formal law has been brought to South Africa by English law, which developed the law of procedure in the course of practical administration of justice. And the English would follow process. That's why probably you get the word due process. You've heard of the word, right? They would follow due process. They want things to be done orderly. And the orderly way, the due process, follows procedure, processes for doing things. It doesn't matter what's the substance, but have you followed due process? Have you followed procedure of doing things? In the next discussion, we've given you an example. For example, civil law, the party claiming damages must institute action, and the party would be the plaintiff. If there's no dispute of fact, the party will issue you will follow application procedure, and then that party will be known as the applicant, and they will defend. The defendant will issue the notice to defend in a certain number of days and file their plea. The other one will issue the notice to oppose, and in a certain number of days file the responding affidavit. So all that happens, it doesn't matter what the affidavit says. The steps that are followed, formal procedural law. But that affidavit is it's not just a blank document. It has got contents inside. It's got information inside. The contents of this affidavit, the information it contains inside, is the substance of this argument. It will even lead you to evidence. You will see Annexure 1B, the proof of payment. See Annexure 1C, the contract entered between the parties. See Annexure 1D, the letter of demand that he must pay the remaining money or he must deliver the vehicle. The moment you go to those things, you are now going to the substance, and that helps you there. So we've done a schematic diagram of, if you were to follow this argument through public law, you then you would have to look at the Constitution or constitutional law, which mainly the Constitution is the source of that discussion. Administrative law, which you look at the acts that influence administrative law, which says when I apply to the state to do a certain thing, how will the state make sure that that thing is done? If I apply for an ID, where must I go? I go to the Department of Home Affairs. When I arrive at the Department of Home Affairs, what happens there? I need to fill a form. After I fill a form, I submit it, take fingerprints. How long must I wait? And what do I expect when I go back? Then you know that you are following administrative law. The administrative actions of an administrator are regulated in law. If the administrator takes your application form, throw it in the dustbin, and do nothing about it, you have got the recourse to complain, to say, but the administrator should have done something with my ID. As the Act now says, if I apply for an ID, I need to get the ID back in a certain number of days. If that ID is not back in a certain number of days, I can now complain and wait a certain number of days for my complaint to be heard. If the complaint is not resolved, I can now take the following step in a certain number of days. So that shows you administrative law. Criminal law, we've discussed it. International law, we've discussed it, both in private international law and international law, raw as it is. Substantive law, we've talked about civil. We've talked about the contents of a document in civil proceedings. We've talked about the things that you find in a criminal case. Was the person pushed? Was the person beaten? Did the person go to hospital? The children, what happened? So you look at the substance. But formal, we said you'll check whether your client has good travel documents. So it doesn't matter whether they're expired or not. Tell me, do you have travel documents? Yes. Then the substance of it is, has it expired or not? Civil procedure, the same. The contents, like we've discussed in affidavit. But in criminal procedure, there's also something, you also find it in civil procedure, evidence. The law of evidence tells you the rules that influence how evidence will be admitted. There is criminal law, there is constitutional law. In the Constitution, it says the Constitution is the supreme law of the country. In the chat, write to me there and tell me, can somebody appeal a constitutional judgment if they're not happy with it? How about also a constitutional judgment? Like I say, I've got a right to my property, and somebody says, no, you don't have that right, but we have this argument at the High Court. Can I appeal if the court doesn't agree with me? And where do I appeal this? In the chat box right there, if you've ever heard of something like that. Busi, Shonope. Somebody says, yes, look, if this thing happened at the High Court, you can appeal at the Supreme Court of Appeal. You start, Lorraine says, you start at the Supreme Court, and then you go to the Constitutional Court, correct? The Supreme Court of Appeal is in Bloemfontein, by the way. It's the only one. You don't have many of those. And from then, you can now take it to the Constitutional Court, back to Johannesburg. High courts, do you have high courts in the area where you are? Where is the high court in the area where you are? If you're around Mdantsane, that should be in Bisho. And where are you? Right there in the chat box, in your area, where do you find the high court? Johannesburg or alternatively Pretoria. Yes, because remember we said they've got concurrent jurisdiction. There's one in Durban and there's also one in Maritzburg, eh? Yes, you've got one in Pietermaritzburg and one in Durban. I prefer the one in Durban. I want to go by the beach when I'm done. East London High Court. And Bisho, do they have a high court? I think there should be a high court in Bisho. These high courts is where these constitutional matters usually get done. Middelburg, it's a regional court. They've got one in Nelspruit. Yes, be sure they have a high court. I think people in Mthatha, they use Bisho. And yes, there's one in Mafikeng for Northwest. Interestingly, if you live in Garangkua, you have to drive all the way to Mafikeng to go to court. And yes, in Free State, the one is in Bloemfontein. Yes. Okay, so you've got the Western Cape one, should be in Cape Town. And in these courts, this is where your constitutional issues get raised. And when you are not happy with it, you have to come past Johannesburg. If you're from Cape Town, you have to, well, you can fly to Bloemfontein direct, but it should be nice. You should first come to Joburg and then go to Bloom. If you're in Bloemfontein, it's nice. So you go to your local high court. If it's not done, you walk down the road and you go to the Supreme Court of Appeal. But if things don't work out there, you'll come back and see us here in Johannesburg. Wow, one in Toyando. That's nice. The one in Toyando, they used to use Polokwane, right? Yes, they used to use Polokwane High Court. Now, those are the high courts where you can find that you can go and deal with these matters, which are constitutional law matters, as you can see there. But constitutional law, you want to discuss all those things. What is the state? How does the state, how is the state constituted? For example, the president cannot go to parliament and vote for a law. He can only sign it into law. He only goes there for questions and answers. He's not the member of parliament. What is the origin of the state authority? Where does the state have power to do things? That's what they're trying to say, the origin of the state authority, the scope of the state authority, how far can the state authority reach? We were having the discussion, I don't know if it's in this class, when we were saying you have a child, it's your child, but in reality, your child belongs to the government. If something happens with that child, there will be the state dealing with your child, and the people called the children's advocates who will come in and then they'll speak on behalf of the child. So the rights of a child get protected by those people. You cannot say, it's my child, I do as I wish. No. Administrative law, I've discussed it. Criminal law, I've discussed it. Just an interesting thing about criminal law. The complainant is the state, and it litigates against the wrongdoer. Public international law, when we started our discussion in the other module, we talked about international law. We used South Africa versus Israel. So we are good on that score. So this leaves us at end of study unit 1 in this. And the next discussion, we are going to have it on Tuesday, where we do professional ethics on this very same study guide so that we can then finish the study guide. We are likely to have a longer discussion on this study guide. We will be having guests from the morning class. The morning class will be joining us because on it's the 19th, I think, on Tuesday, I'll be in court, so I won't be able to attend their full-time session. And they'll be attending with us here. So make sure that you are well behaved. Mava, make sure that you press the shirts and you look very professional. And when you speak, you must speak in a professional manner, because we are going to have guests. And any questions on the chat on what we have discussed so far before we go? We've got about 5 minutes. Or you can unmute yourself and ask a question. You've got 5 minutes to ask questions. Telling you, Bulela, when they are guests, hey, you must behave. You must pull that stand where the judge say, Mr. Pala, please sit down. Then I say, Your Lordship, I'm sitting down, but I'll be standing on the inside. Yeah, well, that should be called to order very fast. But then again, it's one of those things. Hey. Yes, there's going to be class on Thursday. Court ends 3 o'clock, so I should be here very tired and all, or full of adrenaline from arguing in court. We are doing cross-examination and all of that. So it's trial. But I'll be here. I'll tell you nice stories from the courthouse. Okay, yeah, sorry, man. But the recording is available, so you can actually download the recording. Yes, Kuku.
Good afternoon, Mr. Pala.
Good afternoon, Kuku.
Thank you, and class, everybody. Mr. Pala, my question is, let's say we have a criminal matter, it's a murder, and then
Yes.
it was originally at a magistrate court, and then for whatsoever reason, it's then referred to a higher court. What could be the reason of that?
It will always be referred there. It's the schedules. Remember when you looked at the jurisdiction of the courts?
Yes.
It tells you which court handles what matter. And the moment it reaches a certain schedule, that I'll presume is 5 or 6, that matter now gets moved to it gets moved to the high court. There was one case we were doing, some famous case, and the state made a submission that, well, we are only coming here to the regional court to warehouse the matter and make sure that all administrative work is done before we move on to the high court. I had none of it. I say, hi, Pelamatot, how can you come and warehouse our clients here? And it was a big argument. And the judgment came saying, well, a matter cannot be warehoused. A court is a court, but a court is a court to anybody else. But the moment the matter, it's a higher matter, it gets moved. Interestingly, criminal matters, if you say, but Mr. Pala, why did the criminal matter start at the magistrate court, not the high court? My answer would always be, they start there. The police arrest, the thing will go to the magistrate. You remember the Oscar Pistorius case? They all start there. But once they are done there, they now move to the high court, so that the court with something called inherent jurisdiction gets to deal with these things. I hope that assisted, Kuku.
Yes, sir, it did. I have another question, just
yes.
last one. My question is a divorce. They say I want to divorce somebody, and that person is in United States. I'm not sure if I'm saying it right. It's called dictal citation or something. You know, we were talking about jurisdiction and all that. So that process, can it now allows me to divorce the person if that person is not allowed in South Africa anymore.
Yeah, you can do that. But you need to go to court for the court to allow you to do that. So you remember we talked interlocutory steps. So it's a step in between. You now go to court and say, well, we cannot serve the party, especially divorces. They require that the other party must be served. And the Divorce Act would insist on personal service. This person must be aware that they're being divorced. So they will give you an option to do that. You probably publicize that in the newspaper in the area where he ordinarily is in the USA. And if you know him to be on Facebook, poor guy, you now see a Facebook message that says, "Dear Sipo, you have now been served by Facebook. We are divorcing here in Bishop." So you'll have an advertisement, and you take that advertisement and you submit it in court, and court will now accept it as true service. One gentleman in here in South Africa, they tried to serve him and everything, they can't find him. The only thing they could do was to send him an SMS. They came to court, they submitted the copy of the SMS, and the guy was divorced. The lady who was divorcing literally cried in court. You should have seen that thing. It was painful for everyone. She's crying because for 2 years, she's trying to get this guy served and sneaking and diving, and her life is literally on a standstill. So go to court, and the court will grant an order for you to serve.
Thank you, Mr.
Anybody
Pala.
else? This last, none of you have stolen a goat or any other thing. We fix you now. Chop, chop.
Hi, Mr. Pala. My question is,
Technically.
what is the difference between local division and provincial division?
Well, the other one deals with all matters in your province, but the other one deals with matters in your local jurisdiction. Bisho will deal with matters of Umtata and surrounding areas, but East London will deal with everybody, including Umtata, as long as you're in the Eastern Cape.
Okay. So it's just a matter of local and provincial.
Yes.
Okay.
Are we sorted? Tineka, you must call this. You must say, ladies and gentlemen, enough is enough. I'm calling this. Everybody goes home. Tineka, this is on you.
Ladies and gentlemen, this has been enough. It's been very nice. Can we go home now? Are you happy, Mr. Pala?
The matter has been decided. Ladies and gentlemen, see you next time. Thank you very much today.
Goodbye.
Mr. Pala, you very naughty.